Evening, everyone. I'd like to thank you for allowing me to speak on the bills tonight. There are some new members of the committee. Thank you. There are some new members of the committee, so I'll give you a little bit of an introduction so you know who I am. My name is Frank Sarkozy. I am the president of the Second Amendment Coalition. We are the NRA State Association in Rhode Island. I am also an attorney licensed in Rhode Island, Massachusetts, and all the federal courts. I am also a bail commissioner. I've held many hats, worn many hats with regard to different types of experience with firearms on here. I am a concealed carry holder. I have had a license to carry a concealed weapon in the state of Rhode Island continuously since 1996. I'm also licensed in Massachusetts and Connecticut. So, in general, I've been told that I speak too much on these bills and I talk too long, so I wrote some notes out here and I'm going to try to make bullet points and move this along as quickly as possible. There's a lot of people that want to have their opportunity to speak, so I'll try to keep my comments brief on this, and I'll go through the bills one at a time. First bill I'm going to talk about is H5021. That one is, you'd probably recognize it, we named it as like the minor bill. There's a version of this bill that comes up every year. And the original version of the bill has a licensing provision in it where minors could actually get a license on that and they would be able to carry a firearm. Unfortunately, the police departments never enforced it. Well, recently, I've asked quite a few people, when's the last time that the minor could have a license, and it just doesn't exist anymore. So what happens is we had a bill right now that the police departments, they don't enforce. So instead of enforcing it, let's try to modify it and make it worse for everyone else, and that's what they did. Making the prohibition against a minor for having a firearm does violate Section 20 of our hunting laws. Right now, currently, there are minors that actually can take a firearm and actually go hunting. This would prohibit this. This would cause a lot of problems right now for our youth groups, junior rifle teams that have to transport their firearms back and forth to these events. There's no provision in this on here, so all it would do is would create some problems. There's also some ambiguity in the law, and some of the attorneys out here would probably realize this. If you're going to use language in the bill where it says you have to be in the proximity of an adult or a guardian, what exactly is the in the proximity mean? Does it mean line of sight? Does it mean on the range? Does it mean with the person within 50 feet, 100 feet? So now you're going to have a problem where's the line drawn on this? So you're going to have an ambiguity in the law of what is in the proximity of an adult or a guardian at that point. So you have some problems with the bill in drafting it with the language of that. So what had happened is this bill, and when it came in the past, and there's some new members of the panel that may not remember this, or were not part of this panel when the AG had talked about this bill in the past. The attempt on this bill is what it is it's a pretty poorly written gang bill. The AG had testified in years past on a version of this bill that what happens is if they come across somebody in Providence or in some of the surrounding areas that actually has a firearm, the gangbangers will actually have somebody that's a person who's under 18. And what happens is they hand off the firearms to the minor because they know the minors are just going to get a slap on the wrist and they're done. And the other person would not be prosecuted on that. So what this is actually just a poor attempt at... Thank you. It's actually a poor attempt at a bill to go after gangs and them having firearms on the street. So for those particular reasons, we oppose this bill. The next bill we're going to talk about is House Bill 5022. This is the one that deals with shotgun transportation. We oppose this bill. Every year we get a version of this bill that comes out again, and it creates certain problems, especially with the interpretation of laws, what is transporting. When you're transporting a firearm, a rifle, or anything, you're going back and forth to the range. The question becomes, is there any type of detour or route that you can go to? Do you have to go directly to and from that? And now you'd be subject to interpretation of, if I'm going to the range, I'm carrying a rifle or a shotgun, at what point am I in violation of the law if I'm not going to and from that? So there'd be a problem. If you read the bill, and as an attorney, as I read the bill, what it looks like it's doing is the way it's drafted, it creates just a trap. It creates something that can say now, you now have to raise a defense in the event that something happens. And I'll give you the example. If I'm going through from my property in Johnston, I'm going to the range in Foster, and I'm going to Highland, and I call up my friend Mike, and I say, Mike, why don't we go to the range? So I leave Johnston, I go to Warwick. And as I'm driving, I get pulled over by a rookie police officer who knows that I'm the president of the Second Amendment, and they don't like me. So they see that I have rifles and shotguns in there, even though they're transported safely, they're going to say, you're not going to and from the range. What are you doing? So now I can be arrested, and they say, and you've heard this term before, well, too bad. You know what? Why don't you tell it to the judge? So now, at this point now, I'm on the defensive. And I was doing everything legally that I could do, but now that the way this could be interpreted, I now have to create a defense where I'm defending myself when I went to and from the range. And they're going to say, was that a proper detour? Or was I going straight from my house to the range or back and forth? What happens is when I read this bill, something pops into my head, and as an attorney, it's a real problem. It's almost crafted to, when you read it, you say, wow, the person is guilty until proven innocent on this. So this is a real problem with the drafting of the bill, and for that reason, we oppose it. There's also a problem on here, if you read the second half of the bill. What happens if you have a parent and they say, I'm going to take my minor son or daughter hunting, and I may want to take some friends, so I don't have enough shotguns, I may want to borrow one from somebody. What happens is this creates consecutive penalties if that firearm is used by a criminal act of a third party, another minor. So what happens is I could be perfectly legal allowing someone to borrow a firearm to go hunting with for another individual. That firearm gets stolen or used, and now I'm on the hook for that. I had no control of the firearm once I let it go. Now I'm going to be criminally liable on that. In addition to that, we always have to be, as attorneys and as legislators, we have to be really, really careful when we take the discretion away from judges who are going to be imposing sanctions on these type of penalties. This section imposes a consecutive sentence on an individual for the criminal act of a third party. Just let that sink in, some of the attorneys that have to do criminal defense. That's a real problem if you're going to be in court defending something like that. We'll move on to H5332, prohibit incentives for use of a firearm. I read this bill and I didn't understand why we would take away the incentive on somebody if they wanted to have a CCW on that, especially if somebody wants to defend themselves, their family, and they think that this is going to be a problem. I had a real issue with going, why are we even doing this? So I'm not going to talk very much on that one. One of the bills that we actually do support is House Bill 5497. That's the evacuation bill. So what happens is, I look at this bill and I say, this is actually what we really could be considering as common sense firearm legislation that actually works. If there is in a state of an emergency, the police and emergency personnel will be scattered all over the place trying to deal with everything possible on this. They can't be everywhere. The police departments and the emergency personnel would be the first ones to admit, we can't help everybody. We have to do the best we can where we are at that point. So what ends up happening is, in cases of an emergency, this will allow an individual with a short time span to be able to lawfully carry their own firearm, which they own legally anyway. They would be able to keep that firearm and to be able to protect themselves when, in the event of an emergency, the police or the EMT or any other emergency personnel cannot be there. So this is, I think, is a very good bill. It's very narrow in scope, very short time frame. It would have to be a state of an emergency. This really works. Now, there's another aspect on this when I was reading the bill. In the event there is an actual emergency where people have to be evacuated, why would you want to have somebody leave their firearm behind? In the event that there's looters, in the event that there's damage, those firearms may no longer be secure where they were before. And that would leave them open to people stealing them, misuse. If you allow people to take them in the event of an emergency, at least those firearms are within the care, custody, and control of the individual who owns them. So that would be a common sense, good bill that we would probably want to have this legislature support. Next bill I'm going to touch upon is House Bill 5703, which is manufacturing firearms and ghost guns. We oppose this bill. The problem is, when you draft a bill like this, and I take a look at it as an attorney, I look at the definitional section of firearm now, and all I can say is, wow, is it incredibly vague. Incredibly vague. What determines at that point what is going to be considered something that could be possibly turned into a firearm? Who determines that? Is it going to be a police department? Is it going to be a judge? Who's going to be determining that later on? When it's that vague, I would argue that it's actually constitutionally vague. How could a person comply when they could say have a block of aluminum or a block of steel or brass and say, that's thick enough where I could make a lower out of that, or it has the shape where I could manufacture or modify that to make it a firearm. Somebody's going to say, because I have that those pieces, now I'm considered to have a firearm. How does a person comply when the term or definition of a firearm now becomes so vague that you don't even understand what the legislature is, what they intended on that? I read the bill and I'm like, wow, how do I comply with that? Where are the standards? Where are the guidelines? Are we going to be making this up later on in courts when people are arrested and charged, and now we have to go by case law to figure out what the judges are interpreting this by? It's a bad way to make legislation when people can't, when they read it and they can't say, I don't know how to comply with that. So the language gets worse, though. It goes in to say that any combination of parts. So now you have combinations of parts that somebody could interpret and say that those things, all of those things together could be converted into a firearm. So now something that could be completely innocuous on that could now be turned into a firearm. You have a real problem with that. The other thing is, whenever we draft legislation in Rhode Island, we should be taking a look at what Rhode Islanders need, what our legislators have deemed to be appropriate or not. Whenever you include, well, let's just throw into Rhode Island general law what federal law says. You lose control as a legislature to say, under this section, let's take a look at what the federal law defines it. Because the federal law can change and we have no control over that. Now we have to go back and we have to change, because federal law may change and it may not be applicable to Rhode Island. It may be too overbroad, it may be too narrow. As legislators, we want to make sure that Rhode Island law applies and it accomplishes the aim that we put down in the legislation. I have a real problem whenever we put in what federal legislation is, but that was just my own pet peeve on that. And then the legislation then goes on to say that there is an additional enhanced penalty on machine gun, the machine gun provision on here. Machine guns have been incredibly restricted since 1986. They're not allowed in Rhode Island. You have to go through all sorts of federal hoops and registration on those, and they have to get a special tax stamp to even own one, and not even allowed in Rhode Island. So I sat back and when I was reading this going, why are we enhancing a penalty for something that we can't own anyway? By the way, the only people that own machine guns in Rhode Island, the police departments. So why are we criminalizing it? We don't have it. Okay. Another bill that we support is House Bill 5723. This is the taser bill, okay? Now, I know that I didn't watch all of the testimony when I was outside, but I just want to make sure I clarify a few things on this. We actually strongly support this, I know, because I was helping with the drafting of this particular legislation on here. This is actually finally, again, some more common sense gun laws I think we actually should pass. What this bill does is allow for personal protection from an individual who may not choose to own a firearm, but they want to have something that's a non-lethal form of defense that they can protect themselves with. And I'm surprised that we don't have feminist groups and women's groups and domestic violence groups coming forward saying, this is a great bill, we should support this. This is something that could greatly aid individuals in Rhode Island if they want a non-lethal form of defense. Now, again, I just want to make sure, it was probably touched upon before, but there's a difference between a taser and a stun gun. I hope everybody's going over this and everybody, it was covered before, so I don't have to go over it. Everybody in? Okay. I'm sorry? Just know the difference. Okay. Just briefly, a stun gun, you actually have to touch the person to have the shock. The taser actually shoots out dots, and the charge comes across the wires into the individual. The reason what we wanted to have two steps in this process is because if somebody wants to carry just a taser, that requires somebody just to be right up in front of them. That's something they could use. But if somebody makes a determination, they say, look, I want something more. I don't want to have to wait till an attacker is right on top of me before I use that. The concern we had with this and why we had a two-step process was When these dots are being shot out, we want a minimum amount of training on that, and we want somebody like the police departments to say, or the Attorney General's office to say, we feel confident that an individual that's going to fire this knows what they're doing because it's going to be shooting out dots that go into someone. So we wanted a minimum amount of training on that and to be licensed just like a CCW. So this way we feel confident that an individual has this minimum amount of training and can use these things safely. So what we wanted to put in there is created that two-step process. We also wanted to put in place of this in part of this legislation that there was going to be an appeal process. The reason being is we've seen this before when it comes with CCWs, where the police departments decide, I don't want somebody to have a firearm. And they simply, even though it's required in the law, they simply don't issue concealed carry permits. What we're concerned about is in this particular case, if you have someone comes forward and says, look, I have some training, I'd much rather be able to defend myself with somebody 6 to 8 feet away instead of having them right on top of me, I want that. And the police departments go, no, we don't want that. And they simply won't issue the permit. So we have to have a process in place where somebody can say, no, I've received the training, this is what I want. It's non-lethal, and I'm going to be licensed to be able to carry one. So we need to have that in place. In addition, once we put this bill in place, there are certain things that you have to put in there to make sure that you comply with the law. One of them would be to create a self-defense section of this taser law. The reason being is you want to make sure that somebody that uses this, the taser or the stun gun, can use this and that actually a self-defense argument is brought up on this. So somebody can't say, I'm just going to have a laugh, I'm going to zap somebody. They have to be able to use that in self-defense. So there has to be, that particular section was put in there. We also put in there the language that a person has to have reasonable belief that they needed to use that type of either taser or the stun gun, so this way it could be a standard for the judges. In the event that they have to go to court, there'll be a standard or a guide that what the judges can look at it and say, did this person have a self-defense argument to be made? So that's why we put the standard in there. We also put in there that we wanted to make sure that there was no duty to retreat on this, because you don't want somebody to say, okay, I feel like I'm in fear of serious bodily harm. I don't want to have to retreat before I have to use my taser or a stun gun. Now, I'm not sure if this was brought up before. The tasers that the police department use and some of the Capitol Police that you see here, what they use, once that dot goes out and it attaches to somebody, it's just a very short pulse just to incapacitate that individual. What happens is the private sector has some that are made specifically designed for women and men that want to use them, and they have a different setting on them. What happens is they have certain ones that once they shoot out, and the dot hits the individual, the pulse that actually is on there actually intermittents or stays charged for 30 seconds. So what happens is, say somebody is walking across the parking lot, someone comes running at them, and they want to attack them. That dot can be shot out 6 to 8 feet, attached to the person, incapacitate them. The person that shot it can then drop the taser, and that taser, while it's attached, the wires are attached to the attacker, will continue to incapacitate them for 30 seconds and gives them a chance to run away. So that's the aftermarket. So there is a distinct advantage to having the aftermarket, the private sector being able to buy these for an individual so they can get away. So they don't have to wait till the person's right on top of them to utilize those. But that's something, again, we'd want to have a minimum amount of training and have that individual be licensed through the either Attorney General's office or the police departments on that. Okay. Now, I'll speak on House Bill 5728, which is the raising the limit from 18 to 21. We oppose this bill, and there's numerous reasons why I oppose it. But I want to raise something that I've raised before when I talked about this bill. What happens is when I read this bill, one of the first things that came to my mind was, why are we singling out a whole section of public that actually could use a firearm? What do we say to the single mom? And to say, you're alone, you're all by yourself, you're raising your children, you are the one that's primarily in charge of protecting yourself and your family. This person may have gotten out of a bad relationship, they may be a domestic violence survivor. Why are you saying to this person, you can't have a firearm? Not till you're 21. Has anybody thought about the domestic violence survivors that may need this? You're completely eliminating this and giving somebody the ability to protect themselves. What about the women in here? Why the moms and everybody, why are they opposing this? What happens to the domestic violence survivor who says, I need to get something to protect myself? This person may have attacked them before, may threaten to kill them. They may not have faith in that protective order, that that's going to be their primary protection. They may want to be their first line of defense to protect themselves and their family. You're completely eliminating that till they turn 21. That's a real disservice to someone such as a domestic violence survivor who wants that. So I have a real problem when I read this bill and said, why, there's a whole section of the population that is going to be adversely affected by this. The second part of that bill also criminalizes the possession of ammunition. So I'm trying to look at this, and whenever I read these bills, I take a look at the unintended consequences that could come on. And some of the attorneys that are on here, you can see some of these cases that come before us, and it is true when they say it, you know, life is stranger than fiction, because these things happen and you're amazed how these things pop up. So when I first read this bill, I thought, what happens if you have someone like who has a couple of minor children, 18 or 19-year-old children, and they just graduated school and they're looking forward to getting into college, and a girl comes running out and goes, Mom, I'm just going to run down the street to the store for a minute, and she jumps in the car and takes off. And in the back seat on the floor is a single live round of ammunition, a .22. Of course, maybe it's a small box of ammunition that was left in there that they didn't see. What happens if that girl gets pulled over and the officer looks in the back and says, hey, how do you have ammunition in the car? And yet your daughter gets arrested. How do you think that person's going to feel when she's applying for colleges and has to put on her application that she's facing a weapons charge because there was a single round of ammunition in the back of that car? Anybody on here want to get the call from their constituent saying, you passed this bill. Now my daughter may not go to college because she's facing a weapons charge for a single round of ammunition in the back of the car. These things happen. Life is stranger than fiction. And you start passing bills like this, you have to answer to your constituents and say, why did you let that happen? Didn't you think of this? So some of these bills have serious unintended consequences that you really should think about before you start passing them. Now, another bill that I want to talk about is House Bill 5739. This is the magazine limitation. You heard a lot of talk from a lot of police officers are up here, correctional officers, individuals that were here. A magazine limitation, you have to look at it from a couple of different angles. One of them is, we had in place what was called the Clinton ban. For 10 years, there were whole classes of firearms that were restricted. You couldn't own them. Magazine limitations, all different types of firearms were down to 10 rounds. Those limitations and those restrictions were in place all across the United States for a decade. That bill was allowed to sunset because it wasn't working. It doesn't have any real negative effect on reducing crime. There were 2 independent studies on that by governmental agencies, and both came back to the same thing, saying this doesn't reduce crime. It simply doesn't. So you're going to pass a bill that was in place for 10 years that's proven that doesn't work. Has anybody said how anything is going to be different now and it's going to work now? It doesn't. Now, in addition to that, has anybody talked about our businesses in Rhode Island? We have some manufacturers in Rhode Island that make these. Are they now going to be not going to be able to manufacture these? Are we going to be turning away businesses in Rhode Island because of this? There's a real problem with some of that. Now, just as a side note, there's a drafting issue on the bottom. I think it's a question that was posed in there. The language on the bottom part of it has to be fixed. But another question I posed to myself when I was reading this was, how come current law enforcement are the only people that are exempt under this? And you'll hear police officers come forward and say, well, you know, we've had training and we've done this and that, and we should be able to have an unlimited magazine capacity in what we have because of our training. Why is nobody talking about our veterans who actually were overseas and served our country, and now when they come back, are they a second-class citizen next to the police officers? How come they're not exempt? Are you just going to ignore the veterans on that? They have just as much training as the police departments, if not more. Some of our veterans came back from active war zones, but the police are better than that? How come they're not exempt? No one talks about that, which I think is a real problem. In addition to that, a veteran that was overseas or fought for this country now comes back and they're looking at this and they're saying, I can't protect my family as well as a police officer can. Police officer comes home from work probably carrying a Glock with 15-round magazine in it and two 15-round magazine spares. But the person who served our country is limited to 10 rounds. Why is their ability to protect their family restricted? Don't they have the same training? But no one talks about that. But isn't that insulting to our veterans that they have to come back and they're treated like second-class citizens? I spoke about this bill before, and I'm going to give you a little bit of a personal insight onto this. And I told you that I have a concealed carry holder. I carry I'm pretty open about this when I talked about it. I carry a SIG 228, which is 9mm. It's the old-style military version of their 9mm. The factory magazine that it came with is a 13-round magazine. If this law were to pass, everybody's going to say, and you heard all these police officers say, oh, it's going to keep everybody safer. How is it keeping me safer when you just took 3 rounds away from me? Let me tell you the reality, and I said this before. You limit me to 10 rounds on that magazine, I'm just going to carry a spare. Thank you. The reality is now I'm going to carry 20. Because I want a spare. I don't want to have to worry about, well, maybe something's going to happen. And in addition to that, take a look at this from a different perspective. Take a look at this from the perspective of a law-abiding citizen who is home, and there is a home invasion by not one individual, but by multiples. You can look in the newspaper, you can do searches on this. When they do home invasions, a lot of times they go in multiples. They don't go with one person, they go with multiples. So tell me why. Tell me why you're going to limit somebody to 10 rounds when they have to engage multiple targets coming at them from different angles. Is there any reason for that? Because I can tell you right now, if you pose that to a police officer or somebody in the military and said, well, it's safer for everybody, we're just going to make sure your magazine's limited to 10. You'll say, absolutely not. If I have to engage different targets coming at me, I want as much firepower as I can. Why is it limited to 10? When you look at the law-abiding citizen, why is it so I am now limited to 10 rounds for my own personal protection? And the last thing you should take away from this is the question you should pose to most of the police officers that were here. If it's truly safer for everybody, why don't they voluntarily turn in their magazines and all carry 10 rounders? You hear any of the police officers saying that they would do that? It'll be safer for everybody, right? They carry as much as they can because if they have to protect themselves or people around them, they don't want to have a magazine that's limited to 10. They will carry as much as they can. Their right to self-protection is just as important as mine. So when you look at it from that perspective, there is no real reasonable reason to limit my ability to protect myself down to 10 rounds. The Safe Storage Bill, House 5740. When I first read this, the first thing I thought about was, wow, this is a further intrusion into my personal home, my personal belongings. They're going to be able to come in and check now if I'm not safely storing my firearms. In addition to this, and some of the attorneys might like this on there, think of it. If this bill were to pass, does this now serve as a basis for a judge issuing a warrant if somebody says, I don't think that person stores their firearms well? So now you're going to have warrants issued, searches and seizures based on the fact that somebody may have thought somebody else is not storing their firearms properly. Are we doing an end round around the Fourth Amendment on this one? because that could serve as a basis for a search warrant. Got a real problem with that one, because that was the first thing that came to my mind when I read this. And I actually did a little research, and there actually is some problems in other states where that is exactly what is happening. Police departments are doing an end round around this, saying, hey, we got to check. I'm not sure if people are storing their firearms safely. Next thing you know, you got a barrage of police officers in your house on a warrant going, we want to check how you're storing your firearms. Now, House Bill 5741, which is the assault weapons ban, I did talk about it before on with the Clinton ban being in place for 10 years and it wasn't really effective. Take a look at what is listed in there. The assault weapons ban and the definition that you're going to have with regard to what they consider to be a prohibited firearm deals mostly with cosmetic features. Doesn't change the caliber of the firearm, doesn't change the capacity on that pretty much. It's going to fire the same round of ammunition. Whether it has a pistol grip or a different type of grip on the back, whether it has a folding stock or a collapsible stock, it doesn't change the type of firearm it is, doesn't change what type of round it fires. This is all purely cosmetic. Now, the interesting part of this, and I don't think you've heard any of the police officers say this, California passed some pretty extensive assault weapons ban legislation. And you know what the aftermarket community, or the firearms community, did? They manufactured custom pieces to get around the assault weapons ban, to make them legal. So what happens, instead of having a pistol grip where your hand goes right around it completely, there's a piece that's sticking up in the back that goes from the back of the pistol grip right up to the back of the stock. So now your thumb can't go around, your thumb sits on the side. Now it's not considered a pistol grip. Now that firearm, we didn't change the caliber, we didn't change anything, it's now legal. Imagine that. So then you went from a folding stock, you took the stock off the back, changed the buffer tube in the back, and then you put a fixed stock. Didn't change the caliber, didn't change how it operates. It's a cosmetic feature that now makes it legal. What's happening is you're going to be, all these things focus on purely cosmetic features on this. That's all it does. Now, we talk about also about grandfathering here and getting a certificate of possession on that. Last time I checked the Constitution, it was illegal to have a registry in Rhode Island. How are we getting around the constitutional part of this? We're creating a registry in Rhode Island on this. We would have to register your firearms. They'd go to the local police, state police. It's prohibited in Rhode Island. How do you get around that? I don't think it's going to pass constitutional muster on that. But anyway, that's my own personal opinion. Here's another one I thought of. Let's just say you have an individual like a police officer who can now possess these firearms, whereas other people can't. What happens when the police officer goes to work and the spouse is home? That spouse is not a police officer. Are they a felon now because they're in the possession of an AR-15? What about when they have friends and family come over? Are they all felons now because the police officer's family, technically they're in possession of the firearm if they're in there. What if they go in a room and there's one leaning against the wall? How do we get around that? Because technically you could be in possession of the firearm if you're there and you're the only one in the house. So you may have a real problem with that. Okay. Here's another problem with this. Once the list is created, according to the language of the statute, some of these lists can be shared with mental health providers, different hospitals. If you remember back years ago, the Providence Journal actually sued the Attorney General's office because they wanted to know the list of all the firearm owners, or the CCW owners they had in there. Went to the Rhode Island Supreme Court, and the Supreme Court said, absolutely not. You do not have a right to that information. So, question for all the lawyers on here. What happens when you create a list and you transfer the list from the police departments now to a non-police agency? Did you just waive any privilege that you had on that, or any ability for them to say, no, you can't have that information? Is now that list going to be available to the general public? Going to be a public records request? You got a real problem with that, where the list could come out. Here's another thing. There are quite a few cases, because I do a lot of unemployment law, where people who are civilians access medical records. So now you're going to have civilians who are not sworn police officers that may have access to complete lists of who owns firearms. Do you feel comfortable with that? I don't. Because according to the language of this bill, that information can be transferred. And, okay, go to a couple. Let's go to House Bill 5754, which is straw purchasers. Again, with the language on this, when you start putting language in where it says, or otherwise obtained for another individual, the language gets very broad, it gets very vague. You can have somebody who transfers a firearm to somebody else who is in violation of this. It's going to be difficult. Problem comes up with regard to the drafting and the language on that. Also, what happens if it comes up, and I thought of this when I was reading the bill, if a police department or an FBI does a check and clears it, and then later on there's a problem and the person shouldn't have had a firearm, why is the person that sold the firearm ultimately liable? Because that's what this bill actually kind of does. I transfer my firearm legally to somebody else. I go in there, I fill out the paperwork, goes through a transfer. They get a check from either a clearance check from the police department or the FBI and say, yeah, transfer the firearm. And then later on it comes back and says, oh, that person you transferred it to, you knew or you should have known they shouldn't have been able to possess a firearm. You cleared me. Why am I getting penalized for that? So we got a real problem with the straw purchase. I also think the language of it, again, is a little too broad. Okay. House Bill 5762, which is a no guns on school ground. Every year we see a version of this bill come up, and every year I'm amazed that we always push this issue, but we're doing nothing to enhance the security for our children in school, other than going after CCW holders. I'm amazed by that. Every year this bill comes up. Now, I had the ability to watch the presentation by the governor and the Moms Demand Action when they were talking about this, and a personal story was shared about an individual who was sitting in the closet when they were practicing a drill in case there was an active shooter, and talking about how terrified they felt when they were in there, and they wanted to make sure that they wanted to pass bills and legislation like this so that that didn't happen. How terrified they felt sitting in there just wondering, hoping that the gunman doesn't come in there. All this does is evidence that these individuals, the anti-gun people, have absolutely no idea with regard to safety, threat analysis, or any type of situational awareness and how to solve the problem. The reality and the most tragic part of this story is a person who's giving you that story and then saying the solution is that we're going to ban CCW holders from the school grounds and that's going to make it. The tragic part of the story is maybe she doesn't even realize that all she's doing is putting every other one of us in the closet with her, hoping that the gunman doesn't see us, because all it's doing is disarming people like me. So now instead of her and her children being in the closet disarmed, I'm there with her because I can't carry my firearm when I have to go pick up my niece or nephew. You just put me in the closet right next to you, and everybody else on this panel should realize it. It does nothing to enhance our security, nothing at all. Now, again, I didn't hear all the testimony that was brought forward, but did anybody explain to this panel how many CCW holders we have in Rhode Island and what the problem is? All right, so let me give you a little background, because every year when this bill comes up, we've had different people from the AG come up and talk about this. Currently, right now, from the Attorney General's office and all the cities and towns combined, we have approximately 4,000 concealed carry permit holders in the state of Rhode Island. Around 4,000. We have a population of a little over 1 million. Do the math real quick. Less than 0.4% of the population own or have secured a CCW. Most of those, because they're so difficult to get, are ex-police officers, ex-military, and people that need them for their job. So why are we going after less than 0.4% of the population who hasn't done anything wrong? How is that even remotely fixing any problem. It's not. It's going after someone who, extremely small portion of the population, who are your best law-abiding citizens, because they want to make sure that they don't lose their concealed carry permits. Now, I heard this, and as an attorney, it bothered me. Gina Raimondo got up there and said, we need to fix this loophole in the law. This isn't a loophole. This exemption in the law was placed on the books in 1990 by our own Attorney General, who said that in the event sometime in the future we need to have private security on our schools to protect our children, that this would be allowable in the law. This isn't a loophole. This was a specific exemption by our Attorney General saying we might need added security, and we want to make sure it's already in the law. So to categorize this as in a public way and say just for a political gain and say we're going to close that loophole is misinforming and misinforming the public on that. It's not a loophole. It's never been a loophole. In addition to that, the basic premise that everyone knows, it's in any type of security or has done any type of training in the police and military knows this. Gun-free zones are dangerous zones. It's by nature, there is no security there. Take a look at some of the mass shootings, and you've heard people, they've given their personal accounts of mass shootings and what they've heard in the paper. But look back at the mass shootings. Really take a look at it. Almost all the mass shootings that happened in the last 50 years have happened in gun-free zones. Why? Because there's no resistance to somebody going in there that wants to kill lots of people. Gun-free zones don't work. Give you some examples. Sandy Hook was a gun-free zone. The Pulse nightclub was a gun-free zone. Tragically, Parkland in Florida was a gun-free zone. We've said this for years, and I've said this when they came and interviewed us when these bills first started to come out. I said this. Every parent of a K through 12 student in Rhode Island should be absolutely furious at the governor, the Moms Demand Action, the Everytown people for putting forth these bills and trying to push a gun-free zone on our children. Our children go to school every day with no one watching them. And this is their solution? That's terrible. Why aren't they advocating for more money from the legislature for bulletproof glass, for metal detectors, for additional security on there to actually address a real threat that will come to our children? And they don't. All they sit there is smoke and mirrors. Oh, the gun-free zone's going to work. Tragically, it didn't work anyplace else. Why do they think it's going to work now? After Sandy Hook and after Sandy Hook, they went away from the gun-free zones. They added more security. And if you followed the Parkland shooting in Florida, there was a commission that was put together which included some of the parents of the children that were killed. You all right? I have that effect on people, I guess.
You got them choking.
So what happened is the commission, after studied this, they came to the conclusion that the gun-free zone didn't work. They're going to allocate money for added security, for metal detectors, and to really make sure that the schools have adequate security for their children. And that's what I need. And my final point on that is, and the final point on that is, our children deserve much better than this gun-free zone bill. We need to get real security in there so that in the event something happens, they can address that. So, I've been told I talk too much, but I've covered every bill. So if anybody wants to ask me any questions, I'll be happy to answer them.
Thank you, Frank. Any questions for Frank?